All right, hello everyone. Welcome to the Alpha Staff webinar series. Today we're going to go over a little bit about what to expect in the new year and those employment trends we're watching for 2023. We're going to spend about an hour, and our friend from Jackson Lewis, Tassos, who I will introduce shortly, will be hosting for us today. Before we begin, I would like to provide a brief technical overview. As you may have noticed, all attendee phone lines are muted and will remain so throughout the presentation. If you have any questions, please enter them via the chat or the Q&A feature as you think of them, or you can wait to add them at the end of the presentation when we open it up for questions. Keep in mind, if you don't have access to the chat or the Q&A, you can use either one simultaneously. If you can't use the chat, then use the Q&A feature. We'll answer them just the same. Attendance in today's live webinar is approved for 1 credit with both HRCI and SHRM. At the end of the presentation, I'm going to share the contact information so that you can request those credit codes and get a copy of the presentation if you would like to. Now I'd like to introduce our presenter. We have Tassos. He is with Jackson Lewis. He's a principal in the Orlando, Florida office. He's the co-leader of the firm's multi-state advice and counsel practice group, and his practice concentrates on litigation and advising clients in many different areas of workplace law. He's a frequent speaker on a variety of different law topics and has experience developing training programs on those specific law issues as well. He's been recognized by the Best Lawyers in America, Employment Law Management, for 8 consecutive years, and we're very excited to have him on. So Tassos, I will send it over to you now.
All right, thank you for the introduction, and thank you all for joining us today. So it's the beginning of the year, and we wanted to talk a little bit about some of the employment law issues that we're watching this year, things that sort of happened last year and are going to spill over into 2023, and some of the things that we're expecting in 2023 and the trends that we're watching and things like that. And just also to just make you aware of some changes that have occurred. And whenever you talk about a topic like this, you have to talk about the Department of Labor. So what's going on at the Department of Labor? So we expected that the DOL would issue a notice of proposed rulemaking late last year on a new overtime rule that would recommend higher salary levels for the white collar employee exemption. So you might remember a few years ago, they implemented new salary levels of $684 a week for the exemption. And that was lower than the threshold that was proposed by the prior presidential administration. And that was ultimately blocked by a judge. But what we're expecting now is that the DOL is going to come back with a new higher salary threshold for exempt employees. There's some talk that it could be over $60,000 a year, but it hasn't come out yet, but it's something that we're watching for 2023 because we're expecting it to come out this year. And that will be a very major issue for many employers when you have employees that salary exempt employees that fall under that new threshold. We're also watching the independent contractor rule because it's an issue that changes with almost every presidential administration, the way that they define, what qualifies as an independent contractor. So the DOL did issue a proposed rule on this to revise the standard. It would withdraw the current regulations that were issued under the prior administration. And then we would see the DOL going back to its longstanding position of what's called the economic realities test, where the DOL looks at a variety of different criteria for independent contractors. And sort of the big picture there is, what's the economic reality of this relationship? And looking at all of the circumstances without weighing any one factor necessarily over the other. So they would look at things like the amount of skill required for the work, whether the worker has their own equipment and materials, whether the service is an integral part of the employer's business, the degree of control that the employer has over the individual, the permanence of the working relationship. In other words, is it a person who's coming in and doing a particular project and then leaving, or is it someone who's working long-term and they're only working for that particular company, as opposed to having multiple companies that they work with, like you would think a contractor or a vendor typically would. So the bottom line, though, is that you have to watch for when those rules come out if you have independent contractors, because they are going to change and they're going to make it harder to establish that someone qualifies as an independent contractor. Then there's the effect of what's called the major questions doctrine. So this is a legal doctrine that the Supreme Court interprets. And basically, it's a legal doctrine that says administrative agencies have to have clear congressional authorization when they make decisions that have or implement rules that have significant economic or political significance. So a good example of that is when the Supreme Court struck down OSHA's COVID vaccine rule for employers. That was a regulation that the court looked at this doctrine and said, you don't have clear authority from Congress to pass a rule that has such major significance, and therefore it's not valid. And the reason it's relevant is because the Supreme Court has used this doctrine several times in striking down government regulations. So we think that, depending on what happens with the Department of Labor's proposed rule, it might be subject to a legal challenge under this doctrine. And then the final point I wanted to make is that under this administration, we can expect the DOL to be more aggressive in enforcement efforts. The budget that they've requested for fiscal year 23 is much higher than prior budgets, indicating an intent to invest more in resources for enforcement. All right, so we'll move on to the next one, which is pay transparency laws. So there have been some changes in this area, but just a little bit of background first. It was 2019 when Colorado passed the first sort of modern pay transparency legislation, and a lot of states have passed laws on this since then. And California this year expanded its transparency requirements to include wage ranges on job postings. Washington and 3 cities in New York also passed legislation requiring transparency. And we've seen this sort of evolution where, the first wave of laws had requirements for equal pay. And then we saw states pass laws that were part of their equal pay law, but made it easier for someone to establish a claim under the equal pay law. Because equal pay laws are very difficult for employees to bring claims under to win. We don't see a lot of, in the past, we had not seen a lot of those cases. And then the next phase of laws was where states were prohibiting inquiries into salary history. And the reason for that was to stop perpetuating disparities in pay over time. So if historically certain groups had lower pay and employers were asking, what are you making in your current job? And then offering a job that was only slightly above that, it would perpetuate those disparities. So some states say, well, you can't ask about that, what their salary history is before you hire someone. So now the next wave, which is what we're seeing, is prohibiting pay confidentiality. So in other words, allowing individuals to discuss their pay with each other or to publicize it. You can't have a policy against that. And then also requiring the disclosure of pay information to applicants and employees. And that's a very aggressive approach to addressing pay transparency. And in fact, Illinois, if any of you have our employers there, took it one step further, which requires companies with more than 100 employees to apply for a equal pay registration certificate in the state, where you have to submit certain information to the state, including information about gender, race, and wages paid to your employees to get this certificate. So the point is, we expect more jurisdictions to pass legislation in the coming year or years. We expect to see more enforcement of current transparency requirements under the existing laws, and especially when it comes to remote positions and postings that are made on third-party sites, to make sure that the information you're supposed to provide is there. And this has a lot of businesses nervous. When you start publicizing this information, you have to have a plan for how to deal with questions that might come up or issues that might come up. You know, new hires are going to say, you know, I want to get paid at the top of the range. Competitors are going to see what you pay and might try to poach employees. Unions are going to see what you pay to non-union employees. Current employees are going to see what you pay to new hires. So this is all going to raise a lot of issues for employers, and you need to have a strategy for dealing with those problems as they might arise. Next topic is what's going on at the National Labor Relations Board. So we're watching the NLRB, what they're going to do in 2023, because typically when there's a change in administration, again, we see a lot of activity in this area. And one of the things that they're focusing on is electronic surveillance, joint employers. No, some of the things they're focusing on: electronic surveillance, joint employers, and settlement agreements. And I'll tell you a little bit more background about that. So with employees working remotely, there's been a lot more electronic surveillance to make sure employees are being productive, whether it's cameras or keyboard tracking software, other software on the computer that tracks what the employee is doing. And the NLRB's position is that they want to limit the amount of electronic surveillance that employers do, because they feel that it might have a negative effect on employees' ability to discuss and engage in what they call protected activity. In other words, employees discussing with each other the terms and conditions of their employment, whether they should do something about it. And this is not limited to employees who are in a union, and is not limited to employers who have a union. So any hourly employee who's covered by the National Labor Relations Act has a right to be protected when they engage in what's considered concerted activity, meaning discussions with coworkers about terms and conditions of employment. And there's this concern that electronic surveillance would impede that. So there's, they put out an opinion saying, if you're doing electronic surveillance, it has to be very narrowly tailored. There has to be a legitimate business need. So if you have electronic surveillance systems on employees, you might want to take a look at that opinion, or it's a memo that the NLRB General Counsel put out about their opinion on what's lawful in that regard. The joint employer standard, another item that has gone back and forth depending on the administration. So what we're seeing now is the NLRB interpreting joint employer much more broadly than under the prior administration. And under a proposed rule, they're saying that employers would be joint employers if they share or co-determine matters governing the employee's essential terms and conditions of employment. So where this comes up often is in franchisor-franchisee relationships, and also frequently with issues when you have a contract labor force, whether it's a temp agency or just an agency or company that you use to contract labor. Even if the individual is a W-2 employee of the agency or the contractor, you might not have a misclassification issue because they're a W-2 employee, but you might have a joint employer issue if there is some sort of joint sharing of matters governing the employee's terms and conditions. So the point here, it's going to be a lower bar for someone to meet in order to establish that they're a joint employee. And then finally, with settlement agreements, so what's happening there is the NLRB's General Counsel issued a memorandum with this topic as well, and basically saying if you're found to have committed unfair labor practice, the settlement must cover all of the employees' expenses, not just their back pay. So for example, they give, if someone had to pay a late fee for missing a credit card payment or missing their rent payment, or additional interest on a loan, or they needed to, or they wanted new training, new equipment, things like that they had to invest in. So any out-of-pocket expenses associated with the employee's adverse employment action would be something that the NLRB would look to compensate the person for through a settlement agreement. So that's a lot broader than what we used to see. So you're going to see a lot more aggressive approaches to settlement by the National Labor Relations Board. The other thing that we're seeing and watching is continued unionization efforts. So what we're seeing is over the last few years, a significant increase in not just union activity, but also favorability of unions. So according to a Gallup poll from August of 2022, 71% of Americans now approve of labor unions. And last year it was 68%, and it was 64% before COVID. So that's a pretty good jump in a very short period of time. But this is the highest favorability rating for unions since 1965. So that is definitely telling us something with regard to how the public and employees are viewing unions. Now, traditionally, the assumption has been that wages and benefits are driving or are the drivers of union organizing or favorability for unions. But a lot of the companies that are being targeted by unions right now, and you could probably think of some that have gotten a lot of publicity over the last year or two, a lot of those companies are industry leaders in wages and benefits, have wages that have gone up significantly or well above the minimum wage, have lucrative benefit programs, and have even increased their wages and benefits over the past few years. So then, what are the reasons for this increased activity? Well, sure, the top answer when, according to polls, is still better pay and benefits, but almost as important as pay and benefits was job security. And that's where unions come in and, can campaign on that issue that carries a lot of popularity. And then the other popular answer, other issue that's driving this organization effort is employee rights and being represented, having a say in things. So there's this overall pressure on employers to demonstrate sort of fairness and responsibility and representation for employees. If employers are interested in remaining union free, that's something they have to look beyond just wages and benefits. What else is going on? Well, the current administration has made very labor-friendly appointments to the NLRB. We just talked about some of those issues that the NLRB is looking at. There have been social justice movements combined with health and safety issues through COVID that have resulted in high approval ratings for unions. There's a much higher support for unions among younger employees, those under the age of 35. There have been very high profile union campaigns that have gotten a lot of media attention. The NLRB's legal position has changed on some issues where it's making it more favorable for organizing. And the union election win rates are much higher. The union is won about 75% of the time when there's an organizing effort as an employer. So we expect these trends to continue. We expect increased organizing to continue. In traditional areas like healthcare, manufacturing, but now also in union and service sector areas, we're seeing increases there as well. So there's also some uncertainty, obviously, in 2023. There's the potential for a recession. We're going to see whether this continued push by large unions for younger employees is going to last. And then we're going to see how the courts interpret and allow the NLRB's new position and new policies, whether those pass muster with court challenges and how that might assist union efforts. So all things that we're watching for 2023 in this area. Before we go to the next one, I also wanted to mention another tactic that unions have used to gain the success that they have over the last couple of years is we're starting to see more reliance on social media communication and campaigns where it's harder for the employer to control or to respond to the communications. We're also starting to see targeting smaller locations nationally with a coordinated effort as opposed to large sites of the employer. And those are, generally that's harder for the employer to deal with because you don't have centralized management. The person who's the district manager of a particular site isn't going to necessarily be on site and be there to, try to do some of the things employers do during the union campaign. So it all has made it harder for the employer and has contributed to the increased rate of union organization. All right, next topic is privacy laws. So these days, you can't really talk about top issues in employment law without talking about privacy laws. So recently, the California Consumer Privacy Act was amended. And as of January 1st, there are lots of new obligations for employers and people doing business in California. Things like requiring a notice at the time of collection of private information to employees and applicants, posting a privacy policy on a website, outlining, the practices concerning personal information and individual rights, allowing employees to make requests to delete or to know what information you have or to correct information. And this could require also updates to your service provider agreements for your vendors. And then the California law also addresses data security. And then, we're seeing similar enhanced privacy statutes in other states like Virginia, Colorado, Connecticut, Utah, and not necessarily limited to the employment context, but things that could overlap with the employment context. So we, want to be really careful about what's going on in those states, and you should be closely monitoring what's going on in those states and others with expansion of privacy laws. And then on the federal level, the Federal Trade Commission has announced proposed rulemaking as it relates to commercial surveillance and penalties for any lax data security that companies have. So privacy is definitely a very hot issue right now, and I'm going to talk a little bit more about that when I talk about class action trends toward the end of my discussion today. But we know it's going to be front of mind in 2023 for many lawmakers, and there are a lot of legislators, state legislators that are in session right now. So we might see some changes in 2023, but we're definitely seeing more litigation in this area, and that's something that's always foretells liability issues for employers. All right, the next topic. We're seeing more and more use of artificial intelligence by employers for making employment decisions, for screening applicants. And as a result, the regulatory agencies have been paying more attention to how the use of AI could impact employment decisions and potentially create legal issues. So, one of the advantages of using AI is, you might think that that's good in terms of employment liability because it takes out of the equation any biases that individuals may have, right? So if a computer is analyzing data and making, choices based on an algorithm, how can that mean there's discrimination if the algorithm is being applied the same way to everybody? But the DOJ and the EEOC, Department of Justice and EEOC, have raised concerns about potential disability discrimination in these systems. So the EEOC earlier this year released a technical assistant document about technology and disability discrimination. And the DOJ also released guidance that focuses on algorithms and the use of AI in the hiring process. So first and foremost, these documents and these guidances don't create any new legal obligations for employers. It's not new laws, it's not new regulations, but rather are just sort of providing some insight on how these agencies view the use of artificial intelligence. And it's always important to know how an enforcement agency is viewing a particular issue. So the technical assistance documents focus on the most common ways that an employer's use of algorithms and AI for decision-making could violate the ADA or result in disability discrimination. So sometimes spotting disability-related issues in the application and screening process can be very nuanced, right? In other words, whether someone needs an accommodation in the application process or in the screening process, or whether someone has a disability who's going through the application or screening process, the concern is whether or not these systems will flag that. Because an employer has to provide a reasonable accommodation for an applicant with a disability who's going through the application process. And the concern is that the AI might unintentionally screen out and not spot the need for accommodation. Also, to the extent that these algorithms require responses to certain questions, the concern is whether that would violate any restrictions on disability-related inquiries and medical examinations. So these documents, the technical assistance documents, they provide some best practices, such as, obviously, not surprisingly, I should say, training staff to recognize and process requests for accommodation. So the staff who's overseeing the algorithms, the use of the AI, working with the parties who administer these tools, the vendors, to address these issues, informing job applicants and employees who are being rated through these systems that accommodations are available, and providing a mechanism to request an accommodation outside of the sort of automated process that might be used with these algorithms. And describing in plain language the traits that the tool is designed to assess and what methods it's using and the factors that affect the rating that the tool gives to the candidates. Making sure that when these systems are designed, they're not asking any questions about medical or physical or mental impairments unless it relates to a reasonable accommodation. And test it, go through, if you're going to use one of these systems, go through it as an applicant to see whether or not it's addressing or it's easy to find ways to request accommodation using the system. And then, of course, there's also, I just talked about data privacy. You have to be mindful of data privacy issues when you're collecting all of this information that the algorithms are using. Some states have specific notice requirements, consent requirements, disclosure requirements, and other things that employers have to watch out for. So before you use any sort of AI or algorithms to screen or help you with employment decisions, you should look at what the particular states require that you're doing business in. And then we also have state agencies and legislatures looking at this issue. Like Illinois passed a law about consent and transparency a couple of years ago. Maryland passed a law requiring notice and consent before using facial recognition in a job interview. New York City passed a law that creates certain obligations when using AI in the hiring process. So more is on the horizon. California is considering regulations on this, also not surprising. So, make sure if you're already using these tools, I would sort of go back and self-audit them and what the requirements are in your states. But if you're planning to implement something, you have to look at all these legal issues before you go any further. All right, the next topic, which is very recent because it's part of the Consolidated Appropriations Act that the president signed at December 29th of 2022. So what's happening here? We have new laws protecting, federal laws protecting pregnancy and nursing mothers. So we have the Pregnant Workers Fairness Act and the Providing Urgent Maternal Protections, also known as the PUMP Act, for nursing mothers. So the Pregnancy Workers Fairness Act is a pretty significant piece of legislation. It applies to employers with 15 or more employees, and it takes effect at the end of June of this year, 2023. And it's important because, like the ADA, the law requires, it's an obligation to provide reasonable accommodations to pregnant workers as long as they don't impose an undue hardship. So it's the same analysis as the ADA, but the reason this is important is that under the ADA, pregnancy alone is not a disability entitled to accommodation under the ADA. Sometimes pregnancy-related conditions or pregnancies with complications would be entitled to ADA coverage, but not every pregnancy. So this law now establishes that employers have to provide a reasonable accommodation if the employer applicant has some sort of temporary limitation on their ability to do their job based on the pregnancy or related to the pregnancy or childbirth, and the employer has to accommodate that as long as there isn't an undue hardship. So think of it as an expansion of the ADA to pregnant workers, okay? But it adopts all the same meanings as the ADA when it comes to reasonable accommodation, undue hardship. It also states that the employee or the employee's representative can make the employer aware of the limitations. It states that the employer cannot require the employee to take a paid or unpaid leave if another accommodation can be provided. So it doesn't mean the employee gets the accommodation of their choice, but it does provide for an accommodation if in lieu of a paid or unpaid leave. So what's some practical issues is you don't have to have a separate policy under this law. You could, but you don't have to. But if you have an accommodation policy or a policy that gives employees information on how to apply for an accommodation, you should make sure that it includes pregnancy as a basis for getting an accommodation. Think about training. This is a new obligation for employers. So, supervisors, managers, people with authority should have some knowledge or training about what's required here so that they don't miss something. And if you don't already have a process, create a process to follow when employees request an accommodation due to pregnancy-related limitations, which, again, can be similar to the ADA. But you want to make sure you have something that covers these new obligations under this law. Also take a look at your forms. If you have written forms or electronic forms for requesting accommodations, make sure that they're updated to address the requirements under this law. Then the second law, that's the Pump for Nursing Mothers Act. So this expands what were existing employer obligations under the Fair Labor Standards Act to provide employees with reasonable break time to express breast milk, for the employee's nursing child for up to a year after the child's birth. So the employer obligation to provide a place, a private place, continues under this law. We had that obligation before, that's going to continue. But there are also some additional remedies. This law now covers all employees, not just non-exempt workers. Also, the break time may be unpaid unless otherwise required by state or federal law. But if employers, if non-exempt employees are on a break that would otherwise be paid when they're expressing milk, then they should be paid for that break as well. Exempt employees, of course, always have to be paid their full salary, even if they take a break under this law. So, with some exceptions, the law requires employees to provide notice of an alleged violation to the employer and give the employer an opportunity to cure, in other words, to fix it before filing any kind of lawsuit. There are some exceptions for smaller employers in certain industries like airline and rail workers, but you want to make sure that your policies address this law and you're providing what this entitles employees to. Educate your HR team, and again, frontline managers on what the law requires. It's not meant to preempt any local laws that provide greater protection. So make sure you're aware of any local laws on this issue, and make sure you have the the space created to provide for the obligations you have under this law. Okay, next topic, amendments to paid leave laws. So it seems like we see activity in this area every year, and as a result, this has become one of the most difficult areas to track as an employer and as a lawyer for that matter, because there's constantly changes. So in addition to passing new laws, we have amendments to existing laws. So it's not just, hey, which jurisdiction passed a new law? It's also going back and looking at which jurisdiction that had a law made changes to their law. So for example, Washington has a state administered paid family medical leave law that provides 12 weeks of paid leave, 2 weeks of leave due to pregnancy complications. And there were 2022 amendments that expand the reasons for paid leave to include bereavement under specific circumstances. So employees may use paid family leave during the 7 calendar days after the death of a child. The 2022 amendments in Washington also clarify that leave taken during the first 6 weeks after birth is presumed to be medical leave, and employees will be using paid medical leave under the program, not paid family leave. In Massachusetts, there were some changes that take effect January 1. Massachusetts had a paid family medical leave law for a while. So the employers are responsible for sending payroll contributions to the state. The rate decreased for 2023, so you have to make sure you're applying the correct rate. And the Department of Labor also published a new notification, a notice form and rate sheets reflecting the updated contribution rate. So you're supposed to provide those to current employees, the written notification and updates to this law in Massachusetts, so make sure you're doing that. That can be sent by email. You're not required to get updated signatures, so it's just a straight notice requirement. It also updated the definition of covered individual, having to do with what the minimum threshold is for earnings to be a covered individual. They've updated the mandatory poster for 2023, so make sure you have the new poster and that you have it in a conspicuous place like a break room or electronically posted. There was some discussion about changing this law to allow employees to top off their benefits with accrued paid leave. So if their benefits were only giving them a certain percentage of their salary, to use paid leave to make up the rest, but the governor vetoed that change, so that has not taken effect, in case you were wondering or heard about it. So we're also anticipating some changes that might impact obligations to provide health insurance benefits during leave. But that hasn't happened yet, but we're keeping an eye on that. New York also has the paid leave law. There have been some changes to the wage cap under the New York law that took effect January 1. There's also a change in the contribution rate that you pay for the employees. But also, in addition to those more technical issues, eligible employees under the New York paid leave law can now take leave to care for siblings with a serious health condition. So that's a new coverage area that wasn't under the existing law before. California also had some changes to, I know it's not on the slide, but California had some changes to its leave law where they expanded the definition of family member and provided some bereavement leave protection. So make sure you take a look at that as well. Okay, next topic. All right, well, if all of this is stressing you out, there are more protections for cannabis use in many states. So several states passed legislation to provide protections for individuals and employees with respect to cannabis use. So California, for example, if we can just go to the next slide, California previously legalized the use of marijuana and passed legislation prohibiting discrimination against employees and applicants for using it outside of work. So that's something that was missing from the previous law and is now part of that law. An amendment in Missouri approved medical and recreational marijuana, but none of these laws, keep in mind, protect employees who are under the influence while at work. And it doesn't require employers to permit the use of marijuana or to be under the influence at work. So this is strictly protection from discrimination under most circumstances, but it doesn't mean that you have to tolerate your drug-free workplace program as far as being under the influence while at work. Colorado went a step further and decriminalized the use of certain psychedelic plants as natural medicine. But you do have to look at your drug testing and related policies because of the fact that you have now states that are protecting off-duty use of certain substances. And as long as the employee is not under the influence at work, the law is going to protect the employee from termination. So you want to make sure that you're up to date on your policies with respect to that issue. And, in light of these trends, I think we're going to see more decriminalization, more permitting of use. And, that's what we're watching for 2023 and beyond. All right. The next topic is arbitration agreements. If you have or are thinking about having arbitration agreements, there have been some changes in this area. Oh, can we go back? I think, all right, no, I'm sorry, go forward one slide. Okay, sorry, we're good. So I'm going to talk about the ban on non-compete agreements next. That's what threw me off that first line. I'm going to talk about that next. But regarding arbitration agreements, so a couple of years ago, the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act of 2021 was passed. And that amends the federal law regarding arbitration to invalidate arbitration agreements and class action waivers with respect to sexual assault and harassment claims. So this act applies to any claims that arise or accrue after March of 2022. So if somebody was sexually harassed or sexually assaulted at work after March 3rd of 2022, you can't require arbitration of that claim, and you can't enforce a class action waiver of that claim. So that's something that's new for 2023 in terms of any, going forward and starting this year, those types of claims cannot be arbitrated. And you do want to look at your arbitration agreements to make sure that, they're not outdated with their language and that law has been taken into account in your agreements. It does not affect agreements that are valid for issues other than sexual assault or sexual harassment. But we do expect some litigation over the scope and interpretation of this law. We're going to continue to see tension between employers trying to enforce class action waivers in arbitration agreements. So what we're seeing with arbitration agreements is plaintiffs' lawyers pushing back. And so if you have an arbitration agreement that says you can't file a class action, you have to individually arbitrate your claims, and a plaintiff's class action lawyer has, a couple of hundred people they want to represent in a class action, what they're doing is filing 200 simultaneous arbitrations. And your arbitration agreement probably says that the employer is responsible for the arbitration fees, which could be, $20,000 or $30,000 through the course of a full arbitration, not the attorney's fees, the arbitration fees. So do the math. That's a lot of zeros and a lot of commas when someone files 200 arbitrations against you. So we're seeing this tension between, employers seeking to avoid class actions and using arbitration agreements for that, and plaintiffs' class action lawyers pushing back and filing mass arbitrations. So that's a trend that we're going to continue seeing. And finally, there's also been some litigation over, what types of claims the Federal Arbitration Act covers, and whether there should be limitations on the exemptions under the Federal Arbitration Act. So we expect to see some decisions on that over the course of 2023 as well. All right, next one. So this is a very recent development over the past month or so. The FTC proposed a ban on non-compete agreements, and basically a broad ban on all non-compete agreements throughout the country. So this proposed rule would supersede any state laws that have rules that allow non-compete agreements, like Florida, where I live. But it's very broad. So basically it would ban not just actual non-compete agreements, but contract provisions that have the effect of prohibiting competition. Like, for example, if it's broadly drafted to prohibit certain confidentiality, or if you have to repay your training if you go work for a competitor. That's a good example. So let's say you have a provision that says if you leave and go work for a competitor, you have to pay us back for the $10,000 we paid for your training courses when you came to work for us. That would be considered a de facto non-compete clause. It would be a clause that creates an obstacle for someone to leave and go work for a competitor. So this is all in its infancy stages. It's just a proposed rule. It's nowhere near having taken effect yet. There are going to be, I'm sure, lots and lots of comments submitted on behalf of employers in response to this rule. But if adopted, what will happen is, well, first of all, it could also implicate non-solicitation provisions in agreements. So some employers have non-compete, non-solicitation, two different provisions in their agreements, right? So one is you don't go work for a competitor, and two is you can go work for a competitor, but you can't go after our clients or our employees. That's non-solicitation. This rule is drafted so broadly that it potentially could make it hard to enforce even a non-solicitation provision of non-solicitation of customers, clients, and employees. So that's one of the reasons, one of the many reasons employers are concerned about this particular rule. But if it's adopted, basically it would require employers to rescind any agreement that has a non-compete clause, and anything that was negotiated in exchange for the non-compete clause would remain in effect. So to the extent that the agreement with the employee was, you get something in exchange for agreeing not to compete with me. And a good example of that would be, we'll pay you 6 months of severance in the event of termination if you agree not to compete with me during that time period. What this rule would say is, you get to compete with me during that time period, but I still have to pay you the 6 months of severance. That's what the rule says. So that has a lot of employers concerned as well. There is an exception for sale of business, meaning that, if I sell my business to someone and they pay me a lot of money for it, I could be prohibited from competing with that business for a period of time. It's a narrow exception. It applies to people who owned at least 25% ownership in the business. But nevertheless, this is a lot broader than people expected, and it caught a lot of people by surprise. So, what happened was after President Biden took office, he signed an executive order that encouraged the FTC, the Federal Trade Commission, to look at rules to curtail or limit the use of non-compete clauses and other similar clauses. He didn't say eliminate, he said curtail or limit. And this now goes far beyond limiting. So we'll see how far this gets, kind of like negotiations. It might be something where, they put out something that's, goes to one extreme, and then it'll get scaled back through discussions and negotiations, like oftentimes happens with legislation. So, if it gets passed in its current form, we can absolutely expect legal challenges, and that'll probably take well beyond 2023, but we'll see. So if you have non-competes, keep an eye on this. Next and last topic is class action trends. What's going on with class actions? Well, we're still seeing a lot of activity with class actions, especially with the Fair Labor Standards Act and privacy cases. These issues that are going on with class actions are somewhat technical, more legal issues, but just wanted to mention them real quick. I already mentioned the last point, which is the uptick in mass arbitration filings. So I won't talk about that one again, but jurisdictional jockeying, what does that mean? So there have been some cases that address the issue of whether someone who works in another jurisdiction can be a member of a class from a class action claim that was filed in this jurisdiction. So for example, if somebody filed a class action against you in Florida, can an employee from New York join that class? And there have been some cases that have said there isn't jurisdiction for that employee to join a state law class action in another state. So now we're seeing all this litigation in what we call jurisdictional jockeying over who gets to join the class. And of course, what will happen is kind of like with arbitrations, the lawyer might say, well, if my New York people can't join this class, I'll just file another case in New York. Another thing that we're seeing is the rejection of what's called the two-state conditional certification for wage hour class actions, meaning that the way that the rule is now, an individual who wants to join a class or wants to certify a class has to first show that there's an initial threshold to show there's some underlying claim or merit, and then show that there's commonality and numerosity in the class that they're trying to bring. Employers have opposed this two-stage practice because it makes it too easy. There's a very low threshold to establish that you have a class claim, and then notice goes out to all the class members. And then the second stage is the employer can challenge the underlying merits of the claim and try to get the class, decertified. So a lot of courts are siding with employers on this and saying, well, the threshold should be a little higher. Once you notify all these individuals of a class claim, the cat's out of the bag, and the employer should have more of an opportunity to challenge those claims before the notice goes out. So that's something that we're seeing. And then with regard to privacy-related class actions, there has been an uptick in that, and it's one of the fastest growing areas for class action claims. And a lot of it has to do with data breaches and data collection and sharing through websites and other areas. So many of these claims are popular in a class context because you can understand why. If there's some sort of system in place that's wrongfully capturing or sharing information, it's going to affect a large group of people the same way, which makes it very conducive to a class action type claim. Or if there's a data breach and there are 1,000 victims of that data breach, why should there be 1,000 different lawsuits? It's the type of thing that oftentimes is brought as a class action. So There was a case under a privacy protection law that was tried just a few months ago. It was the first trial to a jury in one of these cases in Illinois, and a federal jury awarded $228 million against the defendant, which amounted to about $5,000 per person in the class. That was a huge award. That's almost like Mega Millions lottery money. So that caught the attention of a lot of plaintiffs' lawyers. So to the extent that, just like anything else, these types of cases often settle or go to mediation and they try to get resolved. But all of a sudden, the plaintiffs' lawyers saw what a jury did and started demanding much higher amounts for settlements. So in dealing with these issues, you definitely want to be, from a compliance standpoint, be paying very close attention to your data collection, data breach protection, your local laws and jurisdictions about privacy related issues, to make sure you feel like you can be confident that you're in compliance, because the liability potential is huge on these types of class actions. So maybe not on a down note, but that's what I had to cover today. Those are the sort of a dozen or so issues that we're seeing as hot issues for 2023, or things from 22 that are spilling over to 23. I don't see any questions in the chat or the Q&A, but if anyone wants to present one in there, as we said earlier, the audio is muted, but you can feel free to present a question. Otherwise, I'll turn it back over for any sort of administrative things you need to say as we close this out.
All right, thank you so much. As Tasso said, please go ahead and ask those questions in the chat or the Q&A. Either one will work. So if you have any, in the meantime, I'm going to go ahead and give you some more information about how to get this presentation, and also those credit codes from HRCI and SHRM. You could reach out to us at webinars@alphastaff.com. And you can get a copy of that presentation or the webinar. Keep in mind, if you have any questions, go ahead and type them in. We'll be happy to answer those. And one more point while those questions come in, make sure to join us for the next webinar. It will be next month on the 16th. We're going to go over workers' compensation best practices to ensure a safe work environment from our risk team. That will be next month, so keep an eye out for that.